Item 51.
Yes.
Here the petitioner is seeking the pensionary
Pension.
benefit, my lord. Now that has not been released to the petitioner because of pendency of the departmental proceeding, my lord. Now, the petitioner retired in 2017 and the so cause notice was issued in the year 2018. And
Where you have not filed a return.
Lordship, I have communicated to the department. I need some time to file affidavit because
File the
our
return.
criminal case is
How much
pending.
more time?
It's 2 weeks.
As prayed for by MS S. Sharma, learned standing counsel, PWD, which is not list this matter after 2 weeks to enable the respondent to file their return in the matter.
Obliged.
2 weeks on a date to be fixed by the judiciary. Yes, Mr. Chaudhary.
Not a very short point is
Suspension.
involved. Only thing is, my lord, if your lordship will kindly take note of 3 dates. 30/12/23 was the date of suspension.
30/12.
23.
Yes.
1st of March 24 show cause notice issued.
Yes.
That is within 3 months. But my lord, till date, review has not been done.
Till date review has not been done. What is the stage, Mr. Hendick? You have filed an affidavit, it looks like.
No, affidavit file my.
Deputy Commissioner has filed, Lordship.
Who is the main respondent, Mr. Chaudhary?
It is
Has
the
they filed their return?
Department.
Deputy Commissioner, my lord.
Yes. What is the stand of Deputy Commissioner? The suspension cannot be kept in a limbo.
Yes. My lord, Ajay Chaudhary is very clear. Even if you submit the
There has to
charge
be a
sheet-
review,
Yes.
review meeting.
In fact, my lord,
The
why
reasons has to be
why
given.
we
Suspension is not a
my lord, we
punishment.
talk of Ajay Chaudhary, our manual of departmental instruction issued in 1971 speaks of the same thing.
No, pursuant to Ajay Chaudhary, I think the departments have come up with some office memorandum, if
Yes.
I'm not wrong.
No, my lord, our manual of departmental instruction.
So this there is, I think, an OM of 4th February 2020
Yes,
from the Department of Personnel.
yes.
Correct, if Mr. Bhattacharya?
Yes, Lordship.
So why is it not followed? This OM is very clear. Do you have a copy of the OM?
No,
Mr.
I
Chaudhary?
am not holding it. my lord.
It is.
Have right now.
It refers to Ajay Kumar Chaudhary and
Yes.
it says to the effect that the disciplinary authorities are to strictly comply with the requirement to issue the memorandum of charges charge sheet before the expiry of 3 months from the date of issuance of the order of suspension.
Yes.
It is therefore directed that all the senior most secretaries of all the departments shall ensure that the memorandum of charges charge sheet is served on the delinquent officer employed before the expiry of 3 months. It is very clear. Why is it not done? This is a case where he was put on suspension December 23, so-called notice March 24. Till date, no charge sheet has been given. We are interfering with the
No,
suspension.
charge sheet has been issued.
Charge sheet has been, but it's
But
not
my lord,
completed.
review has not been done.
But it has not.
Even
The inquiry is not completed.
DP is started.
No, there is not question of DP. That's a
And
different
even then,
thing.
my lord, that
My lord, if your
petitioner is
lordship
not
would
in-
kindly have Ajay Chaudhary para 21 for a moment.
Para
21 of Ajay
21.
Chaudhary.
Yes.
We therefore direct that currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee. Now this is important. If memorandum of charge sheet is served, a reason order must be passed for extension of the suspension order. But this part they have not complied.
Yes.
Lordship, right now I'm not retaining this particular judgment, Lordship. my net is not working properly. Lordship, paragraph 22, Lordship may kindly be perused of the said judgment, Lordship.
So far as the facts of the present case are concerned, the applicant has now been served with a charge sheet, and therefore these directions may not be relevant to him any longer. However, if the appellant is so advised, he may challenge. See, Ms. Bhattacharya, what Mr. Chaudhary is saying is that
Lordship.
in para 21 it is made clear that
Lordship.
in a given case where the charge sheet is submitted,
Lordship.
thereafter if it is not concluded,
Yes,
there
Lordship.
has to be a periodical
Periodical
review.
review. Yes, Lordship.
You cannot
Has
keep
to be.
the suspension order hanging.
Lordship. But in this case, this has
This is
been
what
done.
you are saying.
But Lordship, this mandatory 90 days, Lordship, this mandatory 90 days doesn't apply if charge sheet is filed within the 90 days period, Lordship, and the DP started.
My lord, my learned friend has referred to para 22. Consistently, my lord, State of Assam refers to para 22. Now, please come to para 3 of the judgment. Why para 22 is there? Please come to para 2, my lord, at page 295.
Para 2.
Yes. Well, the decision has to be read in the facts. Various litigation was fruitlessly initiated by the appellant in Central Administrative Tribunal Chandigarh bench, as well as in Punjab and Haryana High Court, with which we are not concerned. The appellant asserts that since the subject land was within the parameter wall of the Air Force Station, no physical transfer thereof has occurred. On 28/12/11, the appellant's suspension was extended for the first time for a period of 180 days. This prompted the appellant to approach the Central Administrative Tribunal, and during the pendency of the proceeding, second extension was ordered with effect from 26/6/12 for another period of 180 days. The challenge to this extension did not meet with success before CAT. Therefore, third extension of the appellant suspension was ordered on 21/12/12 for a period of 90 days. It must be followed by it came to be followed by the fourth suspension for yet another period of 90 days with effect from 22/3/2013. It appears that tribunal gave partial relief to the appellant in terms of his order dated 22/5/13, opining that no employee can be indefinitely suspended. The disciplinary proceedings have to be concluded within a reasonable period. CAT directed that if no charge memo was issued to the appellant before expiry of 21/6/13, kindly mark, please come to the Milord, the last date in para 2. 22/3/13 was the fourth extension. It was valid
days.
for 90
90
days.
days.
So 90 days expires on 21/6/13.
Yeah.
Now that is why CAT said, Milord, CAT directed that if no charge memo was issued to the appellant before the expiry of 21/6/13 of the then prevailing period, the appellant would be reinstated in service. So, my lord, in view of this, now come to para 22. So, there was a direction that if by 21/6/2013 charge memo is not issued, he will be deemed to have been reinstated. Now come to para 22. So far as the facts of the present case are concerned, appellant has now been charged with served with a charge sheet, and therefore these directions may not be relevant to him any longer. Direction means the direction in para 21, because in terms of the order of CAT,
But
the charge memo
otherwise,
has
in a
been
given
issued.
case-
Therefore, my lord, this para 22 often government of Assam reads as if in spite of giving the relief in
See,
21.
22, Ms. Bhattacharya,
Yes,
is not
sir.
the law. The law
Lordship.
is in para 21.
Yes.
Lordship.
That law has to be applied in the context of each case, each individual case, correct? Now,
Lordship.
what is the law according to you in 21 para? You read and you tell me. What do you think is the law that has been laid down in para 21?
Lordship, but
Please
there are,
read it and say, Ms. Bhattacharya. Please read it.
Lordship,
have a copy?
right now it's not
Mr.
about
Chaudhary,
Lordship,
can you-
this is
Yes.
Just read para 21.
Lordship.
This first two sentences will do.
We therefore directed the current service suspension order should not exceed beyond 3 months if within the period of the memorandum of charge sheet is not served on the delinquent officer. If the memorandum of charge sheet is served, a reasoned order must be passed for the extension of the suspension.
Correct? So this
Yes, Lordship.
twofold, this is the direction, right?
Lordship.
Correct me if I'm wrong. So here in this present case, it appears that the charge sheet has been served, but till
Lordship.
now the proceedings have not been concluded, and it appears that you have not placed any order whereby you have extended the suspension.
Lordship suspension, it is extended,
Where?
Lordship. Yes, Lordship.
Show me.
Lordship.
Extension is there, Mr. Chaudhary.
Yes, Lordship.
No, that is
Lordship.
beyond 3
Page
months, my lord.
109, Lordship.
Yeah, 100. Page 100.
Page
100.
No, Lordship.
Please come to
100.
100, para 5 of their affidavit.
yes.
That with regard to the statement made in para 4 of the petition, the deponent begs to state
Page
that while
106.
order dated, it was further extended with effect from
Page
19/6/24.
106, Lordship. The order.
It is beyond that period, my lord.
So as of now, there is an order
Lordship.
whereby you have, this is that order 106.
Lordship. Page 106, Lordship.
Kindly see, my lord, they themselves admit, para 5, it is further to be stated there is some delay in reviewing the suspension which was beyond the control of the authority.
This additional period of 3 months have been, is it over? Because it is extended for an additional period of 3 months.
Yes,
With effect from 21/3/2024. When is it?
that is over, my lord.
That is over. What happened after this?
Lordship, the present status that I don't have.
So
Oh,
then-
no. In the meantime, the petitioner has retired from service, Lordship.
You retired.
Yes, Lordship.
Then what survives? This is only for the suspension. For
Yes.
the benefits.
No, but yes, my lord. But because the departmental proceeding has not culminated.
But then extension is there, Mr. Chaudhary.
No, my lord, extension is beyond 3 months. Even if there has to be an extension within 3 months.
No, you
In
need
fact,
to-
our
you may-
departmental,
sorry, if I have understood you correctly, you are saying that this extension on 27 June 24
beyond 3
was
months.
passed after expiry
Yes,
of
after
3
the expiry
months.
of the period prescribed by Honorable Supreme Court in Ajay Chaudhary at para 21. Prima facie, my lord. No judgment to be given.
Oh, yes. And Lordship, initiation of review, Lordship.
There are
This
so
and
many other judgments of
passing
our
of the
court.
final order, Lordship. This is also the Lordship.
In fact, there is a division bench judgment, my lord, reported in 2023 SCC online, Guwahati 731. Then Deepak Mali's case 2010 2 SCC. Then Rekibuddin Ahmed.
No, but
Rafet
that
Ali
is all
Ahmed.
okay. These cases are all contextual.
Yes.
But see, in this case, it appears that after the charge sheet was issued,
Manuel,
there has been an extension.
my lord, it has to be within 3 months.
So, but where is it said that,
Our departmental
Mr.
circular
Chaudhary, you
itself.
can show me
Yes, yes.
from which decision says that
Can
if
I
it
say
is
matter
not
may come
done,
up on Friday, my
all
lord?
right,
Yes.
if it is not
Yes.
done within that
Yes, yes.
period,
Yes, yes.
then the entire suspension order can be revoked.
Service manual kon ase neki?
Service manual, there is some, but that I
No,
think,
my lord, clause I think
remember-
21.8.
yes, I remember seeing that, but I think that has also been discussed in one of the decision of this
Yes,
court.
yes. In
Perhaps.
fact, I think, my lord, the circular of the government of Assam, I can to ase neki? Assam.
What?
And in Deepak Mali's case, it is clear it is written, my lord.
Yes, true.
Deepak Mali's, my lord, 2010 2 SCC 222, paragraph 11.
1 second. 2010.
2010 2 SCC 222.
Aiba. Do you have a copy?
Yes, my lord.
Just mark the paragraph.
Yes, yes, para 11.
It jaldi se.
তোমালোকে কেছ কৰিব আহা কিতাপখনটো আনিব লাগে এই এখন বহিলে নহয় নহয় নাই ইমান কেছ কৰি থাকো মোৰ ইমান মনত নাথাকে দেখোন
So subsequent review and extension,
yes
in our view, could not revive the order which
Yes.
had already become invalid.
yes
So according to you, on that particular day, after the charge sheet was issued, since it was not reviewed, the suspension order has gone. And subsequent order of extension
that
is
will
of,
not
will not
correct the error
Here they have referred to some sub-rule 6 of Rule 10 of 65 rules. Which is
Yes.
these rules?
CCA rule perhaps সেইটো নহয় suspension
In this case, what is the rule that is relevant?
ours is
In
below
our case?
Assam Services Discipline and Appeal Rule
Anything
6.
anything similar of sub-rule 6, Rule 10 there?
Milord, it is not there, but in the departmental instructions, it is there.
Service manual concept.
Manual
Yes.
of department.
Yes, I have this. Yes. Departmental.
Manual of departmental instructions, Milord. I think 2.1.83.
Yes, 2 point.
2.1.8 Roman 3.
In cases where it is not reasonably practicable to prepare the charges for service within 3 months from the date of suspension and the continued suspension of the government servant is considered necessary in the public interest, the authority concerned should move the personnel department through administrative department well before the expiry of the period of 3 months, with a letter detailing the nature of the allegations and the reasons for which charges could not be prepared so that personnel department could advise.
So, Milord, to be honest, this Ajay Chaudhary came in 2015, whereas our departmental manual is of 71.
Yes, anything?
His prayer is for reinstatement. His prayer is for reinstatement. Already
Is
petitioner
praying for?
reinstatement to the service. Let's say.
Is
Prayer
the prayer
personal.
for reinstatement?
Let's say. Because suspension. In the suspended.
But you have already been retired.
I have
Let's say
retired.
that's why.
So there is no question of reinstatement.
There is no
But,
consequences will follow.
if this court comes to a finding
Yes.
that you have not, you having not reviewed within the statutory period, the suspension thereafter is
Not
bad
valid.
and therefore the suspension is revoked, then whatever benefit one is entitled
Yes.
in law, it has to be given.
That has to be my understanding. That has to be filed separately petition.
Huh?
For
What
that-
separate? What separate?
Secondly,
Once the suspension is interfered,
secondly, the senior, my
this is
senior,
a 226.
and otherwise, my senior counsel has relied upon.
Why should unnecessary there be
Para
multiplicity
21
of
of the
proceeding?
other
Why
circumstances.
should be? Huh?
Para 21 of the other study to that my senior counsel has relied on. But para 22 of the other study is less relied.
Yes.
So far as the
See,
fact of the
reading para 21 repeatedly will not change anything. It is very clear.
subsequent para 22 also.
22 is on the facts of that particular case. Why are you taking this quote to that particular case?
Considering para 22 of this
Yes.
of that various ordinance court has passed different orders. These are
That would be contextual. As far as this case is concerned, the decision of Deepak Mali is also pressed into service. It appears that there is within that particular period, there was no order extending. Therefore, subsequent extension is bad. What do you have to say to that? let's only stick to the point that has been raised. Going here and there will not improve your case. This is the main point which you need to address.
Sir, similar.
Can you,
case,
but Mr. Chaudhary, can you ask your junior to give us particular date,
Yes.
which is within the show cause notice came on 1/3/24, correct?
Yes, my lord.
Now
Show code, no, yes.
1/3/24,
Yes.
right? Now from that last extension, what was that period?
90 days would have expired on my lord.
From it was
29.
last extended when?
The suspension is 30/12/23.
Yes.
So January, February, March. So by my lord, 29th of March 2024, the review should have been done.
Expired. But it was done on
It was done much later, sometimes in
yes, Miss
June.
Bhattacharjee, which is that page you had shown?
Yes.
Is it
06 Lordship.
100.
You have done it on 27/6/24.
Yes.
This date is correct according to according
they
to
have
you
stated
both.
in the affidavit.
29/3/24 it would have expired. Is that date correct?
Affidavit con ki hoga?
Are you referring to para 5, Mr. Chaudhary?
Yes, my lord. Page 100.
Yes.
That with regard to the statement made in paragraph 4 of the petition, deponent begs to state that by order dated 27/6/24, it was further extended with effect from 19/6/24 by order dated so and so. The petitioner's suspension was duly reviewed and extended due to ongoing departmental proceedings and the gravity of the charges.
Now, just here it says extended with effect from 19/6/24.
Yes.
Why 19/6/24
I
when
don't
it
know.
expired according to you on
Perhaps
20?
their understanding is, my lord, it has to be done within 6 months.
Do you have these dates,
No,
Mr.
Lordship.
Chaudhary? Because
What date?
I need some clarification in the dates.
My lord, if they would have done any review prior to that, they would have disclosed in the affidavit.
Your para 5 doesn't say anything, but why is it why that 27/6 extension is from 19/6?
What is the significance of that? then?
There were so and so for the extent with effect on 1960. Yes, 27/6/24 Lordship, the order was passed.
With effect
And is
from
given for effect from 19/6/24.
why
Lordship.
19/6? Because it looks like from the dates that are
I think
available in the
19
petition, the
19
suspension
most
order would have lost its force by 29/3/24.
Duly ongoing permanent person, the gravity of service, so and so,
To get a clarification, because I have to author a judgment, I need the dates
Lordship.
at least proper because these
Lordship.
dates are important. Tomorrow,
Lordship.
list again tomorrow. It will file.
DPW.
এইটো থৈ দিব হা তাত অজয় চৌধুৰীটো গুচি গ'ল নেকি সেইটো মোক ইয়াত লাগে ইয়াত দি দিব
Made please, Lord.
Yes.
This is a pension paper, Lordship. I have
Affidavit
written.
not filed, Mr. Upadhyaya.
Lordship, it is a covered case, Lordship. Actually,
Covered case?
I have given that.
Sanjita Roy.
Sanjita Roy, Lordship. I have completed 25 years of service.
Where is the judgment?
Judgment I have given, Lordship.
Medicine, Upa?
Judgment.
Which is the operating part? Paragraph?
Operating part, Lordship. 20, Lordship. Lordship can 29 and 20, 30, Lordship.
20?
29 and 30, Lordship.
I think I have also disposed one case perhaps in this line. Were you there in that?
No, Lordship. After this, Lordship.
So you are agreeing that it is covered. 53, huh? heard Mr. D. Mohanta,
Dilman.
learned counsel for the petitioner's club, also heard Mr. N. Upadhyay, learned standing counsel irrigation,
Lordship, refer
irrigation,
number
Mr. A. Chalia, learned standing counsel finance, M. Bhattacharjee, learned additional senior government advocate for the state respondent. Yes, AG, A&E. Is Mr. B. Sharma or Mr. S.K. Medhi? Mr. S.K. Medhi, standing counsel AG, within bracket A&E. By filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking release of the pension benefits of the petitioner. It is submitted that the petitioner had served for 25 years and 11 months in the concerned irrigation department, and her services were regularized with effect from 22/7/2005, and only on the issue of completion of the qualifying service, the pensionary benefits have not been given. Stop. It is submitted at the bar that the issue involved in the writ petition is covered by the judgment of this court rendered in the case of Sanjita Roy and others versus State of Assam and others, reported in 2019 volume 2 GLT at page 805. In view of the endorsement made above, in view of the endorsement made by the learned counsels appearing for the parties, this court considers this court in the interest of justice considers fit to dispose of this writ petition in accordance with the decision of this court in Sanjita Roy and others Supra. Accordingly,
Impugn order is page number 16. Page number 16, impugn order.
no, I shall direct the respondents to pay the pension benefits. Accordingly, the respondent authorities are directed to pay the pension benefits of the petitioner immediately in terms of the aforesaid decision of this court. Disposed of.
Time framing. Time framing maybe we can 2017.
Whatever is there in this, it will be there. It is needless to clarify that the aforesaid exercise shall be completed within a period of
3 months.
3 months from the date of receipt of the certified copy of the order.
Obliged.
Disposed of the. Yes.
Here, the petitioner was serving in the Defense Service Corps and was sought to be discharged on medical grounds. Now, before his discharge, we approached this honorable court.
Affidavits not filed?
No, Lord.
Here I was praying for an interim on the first date. If Lordship will kindly have
Interims are only meant to be considered on the first.
that is what I'm trying to.
Once you miss the bus,
No, we did not. That is what I'm trying to point out.
the last order doesn't say anything.
If Lordship will have order dated 31
Let her get the
24.
instruction. By one, when?
She has the instructions.
Lordship, that specific instruction that invalidating medical board was, whether it is there or not, that is that no invalidating board was there, but medical review medical board was there, and he had some restriction regarding his employment, and it's
Why are you not filing an affidavit?
Lordship, I have received certain instruction. I am waiting for the complete instruction.
You
So I'm-
file it.
Yes, Lordship.
I'm giving you 1 week's time. We file it and we can have this matter before the vacation. Because it is only whether the perhaps the issue involved here is whether the petitioner is fit or not
No,
for the job.
only issue is that invalidation board was held or not. That is the only issue.
That she's saying it has
Not held.
It was not
So
held.
ultimately, the Supreme Court judgment I have supplied, my lord. It is held that he has to be reinstated. Yes, I had given
Yes,
the
yes,
last
yes, it
quotation.
is there.
Lordship will have
Paragraph?
right. Right. The same law, the same sections of law. Everything was the same here.
Can you read?
The High Court, by a well-reasoned order, concluded that the discharge of the respondent without holding an invalidating board in terms of Rule 13.3.1.2 was illegal. As regards the applicability of Army Order 46 of 90, which contemplates that the employment of permanent low medical category personnel at all times is subject to availability of suitable sheltered appointment commensurate with the medical category, High Court held that before the opinion is formed as to whether a person is to be retained or not on the medical ground, there has to be an opinion of the invalidating board to the effect that further retention in service on medical ground is not possible. The question of suitable sheltered appointment commensurating with the medical category will be relevant only thereafter. According to the High Court, there is no rule stipulating that as soon as a person is placed in the low medical category, it will be presumed that he is unfit for further service. Consequently, High Court allowed the writ petition, quashed the order of discharge, and directed the appellant's hearing to reinstate the respondent in service. Then Lordship will have page 32, paragraph 32 on the last page.
Yes.
For the foregoing reasons, we wholly agree with the reasoning and conclusions of the High Court that the discharge of the respondent was not in accordance with the prescribed procedure and was therefore illegal. We do not find any illegality or infirmity in the impugned or judgment and order warranting our interference. Appeal, therefore, being devoid of merit, is dismissed accordingly. If this happens after a
So
year,
the High Court had allowed the writ petition
yes,
because there was no invalidating board.
that was the only issue.
That was the issue. In
Invalidating board
and
says so. I go.
the apex court have affirmed
Yes.
the judgment of
And
the High
Lordship may
Court.
also like to have a
In your
look.
case also, the issue was whether there was an invalidating board or not.
That is not there.
Lordship, prior to paragraph 28, 26 is there, Lordship. So if we have to read it, we have to not only the last or
Yes, yes, please
yes,
read.
Lordship. It is mentioned, manifest that the said army order has been issued for disposal of permanent low medical category personnel and merely contemplates that the employment of permanent low medical category personnel at all times is subject to the availability of suitable alternative appointment commensurate with their medical categories and also subject to the condition that such a shelter appointment can be justified in the public interest. A plain
You are
reading of
reading paragraph?
26.
Yes.
A plain reading of the army
No,
order
but
shows
where,
that
where in paragraph 26 starts with it is well settled.
no, it is
No,
manifest.
Para 30 is what she's referring to, my lord.
Paragraph?
Para 30.
It's
A plain reading of the army order.
yes, yes.
Just
No,
before
no.
that, I think it is manifest.
It is manifest. It is manifest that the said army order has been issued for disposal of permanent low medical category personnel and merely contemplate that the employment of permanent low medical category personnel at all times is subject to the availability of suitable
Alternative
So-
appointments. Look,
retained in service. But is stipulated in army order.
Suitable alternative
No, I don't-
appointments
I don't know.
commensurate with their medical categories.
Yes, Lordship.
And also subject to the condition that such a sheltered appointment can be justified in the public interest.
Yes.
Public interest.
A plain reading of the army order shows that it comes into
Operation after an
Yes.
opinion has been formed as to whether a particular personnel is to be retained in service or not. If so, for what period? If a person is to be retained in service despite his low medical category for a particular period as stipulated in the Army Order 46 of 80, the question of subjecting him to invalidating board may not arise. However, if a person is to be discharged on the ground of medical unfitness at that stage of his tenure of service or extended service within the meaning of Army Order, he has to be discharged as per the procedure laid down in clause 1-2 in column 2 of the said table. Similarly, sub-rule 2A of Rule 13, heavily relied upon by the applicant, does not carry the case of the applicant, and further, it is only an enabling provision to authorize.
What are you trying to draw home, Ms. Sharma?
Lordship, here it is not that he was discharged without any medical board. That review medical board was there, and it is not only for one time. We have examined him many occasions. At first, he was
All right, you file your return.
Lordship.
Let the return come. It cannot be disposed of in this fashion because he wants to distinguish that
that review medical board.
with
was
all
also
fairness
there.
that right has to be given to them. Yes, heard Mr. R. Majumdar, Learned Counsel for the petitioners. Top also heard MSB Sharma, Learned CGC. How much time?
2 weeks, Lordship.
as prayed for by MS B. Sharma, learned counsel for the respondent, list this matter after 2 weeks on a date to be fixed by the registry to enable the respondent to file their return in the matter. Stop. It is needless to clarify that if the returns are not filed by the next date of listing, the writ petition shall be heard in accordance with law.
Applied.
None appears for the petitioner when the matter is called. List after 4 weeks on a date to be fixed by the registry.
6 years loss.
Yes, why are you all looking so lost?
Also, in this case, last occasion,
Cut that
in
order.
this case, last occasion, directed me to produce the record loss. I have received the record. I'll allow 1 day time to go on for the record loss.
Yes, Mr.
MJ Gogoi.
NJ
Gogoi.
Gogoi, learned counsel for the finance department.
No loss. I am for the Assam State Aviation Marketing Board.
This is item 658.
Yes, 68. 68. Item number 68.
You are for the Assam Standing Council, Assam State Agriculture Marketing Board submits that he has received the records as called for earlier by this court and accordingly seeks 1 day accommodation to look into the records. Prayer is not opposed. List on next week that they did on such and such date.
Obliged, sir.
One matter out from this series was, I think, withdrawn in the
No,
morning.
that is the main case, Lordship.
Huh?
That is the main case.
That main case has been withdrawn.
Yes, Lordship. Here challenged the promotional order.
You have withdrawn it in the morning.
Here,
Yes, I have withdrawn Lordship.
That is
And
gone.
Now this other matters will also not survive because only because of that order, Lordship.
The interim order passed in that case was that my promotion will be
But
subject.
that has he has withdrawn it.
Withdrawn, yes, that's
You were firing the gun, putting it in his shoulder. The shoulder is not there. The gun is going to fall down. Correct, Mr. Dhar. So what to do?
Madam, here if Lordship orders
Are you
that-
withdrawing?
Madam, I would not be withdrawing because they have they have not paid my salary on that account. So if Lordship observes that the main writ petition having gone, these writ petitions, the reason why they had not given me now no longer survives. If
So it's
Lordship-
become infectious.
Therefore, respondents will now take steps for releasing whatever benefits.
The problem is, Mr. Majumdar, you people say it with so much of conviction because you are aware of your facts.
I
But this court has no idea
I'll
because
just-
the first that item
will-
number 70 was simply withdrawn.
My lord.
So I have got no idea what is the issue involved.
I'll just point out, my lord. At page 21 is my promotion order.
One second. Prayer is what? To release the arrear of the salary. And in this item 70, what was challenged?
My promotion orders to the post of statistical officer
The
was
same
challenged.
petitioner.
One petitioner has challenged all the other writ petitioners. So there was an interim order passed which said the promotions made will be subject to outcome of the writ petition.
Now that has been withdrawn. So
And the-
then you are entitled for your salaries.
That is the
yes, that anyways we.
Item 75 to proceed. Do you have a copy of that interim order?
Yes, madam, at page 27.
Just hear out the order. Huh? Heard, Mr. Please give your Mr. Majumdar. Are you appearing in all the writ petitions?
Yes.
Your heard, Mr. R. Majumdar, learned counsel for the petitioner. Stop. Also heard, MS
Our Bora Lordship.
R.
Bora Lordship
Bora.
for the Agriculture
Bora.
Department.
R. Bora, learned standing council, agriculture.
Agriculture Lordship.
D. Sharma, learned counsel
private
appearing for respondent number 6 and 7. Finance. Mr. A. Chalia, Learned Standing Counsel, Finance Department. Yes, AG, Mr. Medhi. SK Medhi, Standing Counsel.
We are for all the
There are several matters, so all are representing the different. All means Mr. Medhi, Mr. Sharma, Mr. Bhattacharjee, and okay, Mr. SK Medhi, comma, Mr. B. Sharma, comma, Mr. Chakraborty also. B. B. Chakraborty, comma, R. Boro, R. K. Talukdar, D. Bhattacharjee for learned for Standing Counsel AG.
My lord,
And R. Dhar, yes,
WPT and BC.
for W,
PT and BC.
PT, and BC. Anybody left out? Stop. In these petition, the petitioner under in these petition filed under Article 226 of the Constitution of India, comma, the petitioners are seeking release of the arrear salary corresponding to the post of Statistical Officer Agriculture, scale of pay band 3 of rupees 22,000-87,000 plus grade pay of rupees 11500 per month plus other allowances as admissible under the rules with effect from 22/9/2020 when they joined in the said post at different places at respective places in pursuance to the order dated
Page 22.
19/9/2020 forthwith. Stop. It is submitted at the bar that the appointments of the petitioners were the promotion, right? The promotions of the petitioners were put to challenge in WPC 4373 of 2020 by one Moinul Haq Chaudhry, by the petitioners, i.e. Moinul Haq Chaudhry and another. Let me say by two persons, i.e. Moinul Haq Chaudhry and Dhurbajoti Soikia. Wherein this court, by order dated 21/10/2020, while issuing notice, was pleased to direct that any promotion made in favor of the respondents shall be subject to the result of the said writ petition. Stop. Pursuant to the said order passed by this court, the salaries in the promotional post was not released to the petitioners. Stop. Today, when the matters were listed for hearing, along with WPC 4373 of 2020, comma, the learned counsel appearing in WPC 4373 of 2020 submitted that he has received instructions from his client not to press the said writ petition, and accordingly this court by order dated so and so was pleased to dismiss the said writ petition, i.e. WPC 4373 of 2020 as dismissed on withdrawal. Stop. Situated thus, the observation made in order dated 21/10/2020 also automatically stands vacated. In view of the above, there is no bar for releasing the salaries to the petitioner in the promotional post in accordance with law. As such, nothing survives for adjudication in the present writ petitions. Accordingly, the writ petition stands disposed of for being infructuous. All right.
Promotional, the salaries, and consequential promotional benefits.
And consequential promotional benefits. Otherwise, everything remains same, right?
Everything remains.
The figures and that post
Well,
statistical.
the date of joining, if Lordship would say from the date they joined, because someone might have joined the day here and there.
Is it required to be said anywhere?
Lordship said 20, Lordship specified 20.
Of instead of
So I said it's from the date of the joining.
from the date of joining.
That would,
Put a star and say from the date of joining. I think in that first part of the order it is mentioned. Okay. A date
22/9/2020 would be changed to date of
22
9
9
2020
2020
That
will be
day will be
replaced
changed.
by from the date of joining.
instead.
To the promoted post.
That is already said there.
I'm deeply obliged, my
So this takes care of item 69 to
70
7
70
huh? To 80.
80
80. All right.
80 yes, sir.
सब disposed. Supplementary. Yes, Mr. Achar.
Yes, in this
Mr.
case, I am the amicus appointed to assist the petitioner in person, my lord.
Contempt matter.
Yes, ma'am. Lordship will have a look at the order of 8/4/24.
This matter, contempt matter pending from 2022. Order?
8/4/2024.
Where page?
My lord, in the order sheet of this proceeding. Now, in
Order
that-
dated?
8/4/24, 8th of April 2024.
Yes.
Lordship will say that there is
He also submits that
Yes.
the arrears salary of the petitioner has already been paid to him except for a period of 13 months.
13 months.
I.e. from 1797 to 1798.
Yes, the Lordship may kindly look, note that period. 1797 to
Yes,
July
1798.
98. Now, if your Lordship comes to the order passed on 26/6/2024 in this petition, in this
Yes.
proceeding, Lordship will see that a sum of rupees 1,09,328 has been sanctioned for payment to the petitioner as arrears salary for the period 1197 to 6198. Though the original period was from 1797 to 1798, but the payment was made for 1197 to 6198. Then my lord may have a look at the order passed on 29/7/2024. 29/7/24.
Yes.
The second paragraph. On consideration of the above submissions so advanced by the learned counsel for the parties, it is seen that the salaries for the petitioner from 7/1/98 to 7/17/98 is still not clear, and accordingly 15 days time was granted. Now, whether the payment for this period has been made or not, this is the question which, to my understanding, remains.
Lordship will peruse the next order, Lordship, which might. 38/2024, Lordship. 30 of August 2024. The next order, Lordship.
Next order after 22/7, the next order is 9/9/24.
After 29/7, Lordship, there is
There is an order of 38.
30th of August, Lordship.
That order.
It was passed by Honorable.
Okay, 38.
Yes, Lordship.
It is noticed that though entitlement according to the respondent authorities have already been released to the
Exactly.
petitioner, the representation directed to be disposed of has not been considered.
My
And
lord-
disposed of as on date. What does this mean?
My lord, let me complete before my.
First of all, where is the order of this court?
Yes, Lordship.
Let us see the order of this court.
Page 17, Lordship of the contempt.
Page
17, Lordship.
17.
Yes, Lordship. The direction is given over there. Lordship will just.
The petitioner
Yes,
in
sir.
person has submitted that he has not been receiving his arrear salary as well as non-practicing allowance. In this regard, the learned standing counsel health has submitted that steps has already been initiated to grant the benefits to the petitioner in person. However, so this is the operating portion of the order.
The operating portion
Is one.
17.
Liberty is granted to move the competent authority as well is provided that if such representation is filed by the petitioner within a period of 1 month, the competent authority shall dispose. This representation has not yet been disposed.
Lordship,
On the last day, they have
Lordship,
disposed of.
Not on the last date we have placed the order.
It has been disposed.
Lordship.
So this part hasn't been complied.
Complied.
Then what remains?
Then number 2, the petitioner
Person
person
has submitted that he has not been receiving arrear salary. In
and
this regard,
non-practicing allowances.
Submits that steps has already been initiated. However, the petitioner would be free to raise his grievance for the same by his representation. It is in the petitioner has further grievance except.
Lordship, now if I may,
But Mr. Chakraborty,
in
this
my
is a contempt jurisdiction.
yes, Lordship.
My lord,
There is no specific direction of also in that Roman 2 that this has to be paid.
We have already paid, Lordship.
Wait.
my lord, why my friend jumps up
Because
every
they're
time?
wasting the court's time.
Mr. Cholia, please be
That's
mindful of what you submit before the court.
I apologize.
This is a court proceeding going on.
Lordship, I
The
apologize.
petitioner has all the right to make the submissions.
Lordship, I
And most
apologize. I
most
apologize.
importantly,
Yes.
I'm not for the petition, I'm the amicus, my lord.
Yes, and he's
But-
a friend of the court.
Lordship, I
So
apologize.
please
I
be mindful.
Lordship,
Please take your seat. Yes, Mr.
Now, my
Chakraborty.
lord, there was a direction.
See,
that-
Mr. Chakraborty, you are getting what this court is
Yes,
asking, right? Because this court is now exercising a contempt jurisdiction. Therefore, you must show that there is a positive direction, and that direction has not been complied. Then the questions will come about deliberate, willful disobedience, and this court can go into the matter.
My lord.
But what you have already shown, and what have been shown by the lawyer for the contemptor, is that the representation is disposed. Whatever is to be paid, they have made a calculation and they have paid. Now, if there is any dispute, how can this court in contempt
No.
jurisdiction go into all that?
My lord, first.
Are you understanding
Yes,
what
I understood.
So you address this.
My
Yes.
lord, there was an lordship may come to this Roman to the petitioner person submits that he has not been receiving his area salary as well as non-practicing allowance. In this regard, the Learned Standing Council for Health Department has submitted that steps have already been initiated to grant the benefits to the petitioner in person. Now that was a statement.
Yes, where is the order of the court?
Now, in the contempt, but when the contempt was filed, the representation was not even disposed of. It has come.
See, that
recently.
is a different thing. But this contempt proceeding has been filed alleging non-compliance of this particular order.
Yes,
Am
my
I
lord.
correct?
Yes,
Now,
my
in
lord.
this,
And
the order of the court is for disposing of the representation. Am I right or not?
Yes.
That is the order.
Yes.
And that apparently has been now done.
Disposed of.
Now, the second part is a liberty given to them that if you are not given, you are at liberty to raise this in your representation.
No. Liberty
Yes,
is
read-
other thing, my lord.
No,
So
it is-
representation, liberty for disposal of the representation is the liberty.
It says in this regard, the Learned Standing Council has submitted that steps has already been initiated to grant the benefits to the petitioner in person.
Yes.
However,
The
the
petitioner,
petitioner in
person
person would be free to raise his grievance for the same by his representation as indicated herein above. Here before.
my lord, in the representation, they have disposed of and they have stated that they have paid some amount and they have
So
made
that
them.
is why this court is asking you how this court in a contempt jurisdiction will further go into the matter. This court is not the executing court. They have disposed of the representation. If you are not satisfied with the outcome of the disposal of the representation, you are at liberty to approach an appropriate forum,
My lord,
isn't it?
on 8/4, there is a specific submission of the council that the area salary is for a period 1797 to.
I'm sorry, I
My
shall
lord,
not go by all that.
My lord,
Because as far as this court is concerned, the court is only concerned whether there is a willful, deliberate disobedience of the order dated 8/3/19.
my lord.
This is the issue. Apparent the representation has been disposed of.
My
You are at liberty to file appropriate
can challenge the speaking.
challenge if needed.
But the period of, my lord,
How can this court go into?
What
This
the-
is not the executing court, Mr.
No, my lord,
Chakraborty.
it is not the executive
Then-
court. The question is that area salary is for a period of 13 months and their stand is that they have made the payment. But the order shows that they have
I
made,
understand what you are saying.
and there is
but
an order of,
Mr. Chakraborty, the order dated 8/3/2019 does not carry a direction to the author to the respondents to make this payment. That positive direction is not there in this order.
but at least, my lord, on 29/7/28, there is another order
I'm sorry.
because
Yes, where is the represented disposal order?
Lordship, the speaking order. quantum, that also has been explained, Lordship, and I have placed an instruction. Now, the manner in which how we have assessed, that is being questioned by the authority.
No,
Yes.
it is not the manner.
We have
in-
paid.
All right, all right. All right, Mr. Chakraborty, I'm closing this contempt petition.
But my lord will appreciate one thing, that though they have stated that they have made the payment for the entire period, but the orders shows that it was
Mr.
for a particular
Chakraborty, the
period.
merit of that disposal representation, can this court go into?
The disposal came later on, but these submissions came before because all the payments were made during the pendency of this contempt case, my lord. Everything, if your lordship takes up this payment has come during the pendency of this contempt case. And my lord, in the contempt proceeding, they have made a statement that we have to pay a amount of 13 months. Lordship will see that on 8/4/24, if your lordship goes to the order, there was a statement from the council that his arrears salary is for a period of 13 months, commencing from this date. We are going in the process, we are making the payment. And in fact, they made a payment, but they have made a payment for a period lesser than the 13 months. When pointed out, there is a direction of, my lord, 29/7/24 to make the payment. 29/7/24. Second paragraph. On consideration of the above submissions so advanced by the learned counsel for the parties, it is seen that the salary for the petitioner from.
So, Mr. Chakraborty, even that order of 6/5/24, here also it says that they have paid. Now, this court cannot go into the dispute of the amount.
No, it is not the amount,
And
my
that
lord.
is not also the order of this court. If there is any dispute, you raise it in an appropriate forum. I'm not closing the door. You have appropriate forums for where you can raise these issues. As far as this contempt court is in this contempt case is concerned, the only issue is whether the order dated 8/3/2019 has been complied or not. That has been complied with this representation.
And my lord, during
Are you following what I'm saying?
Yes,
Now,
I
how
follow.
can I enlarge the scope of the inquiry in this contempt proceeding?
Because, my lord, in the meantime, although they have made the payment during the pendency of the
According
contempt.
to you, it is short.
Yes.
I have understood. You are saying that short payment has been made. But what I'm trying to tell you is that that is not the direction of this court in that order. You know, the order against which you have come for contempt. There is no direction in the order dated 8/3/2019 to the respondent authorities to make these payment. There is no order. Please point out if there is an order. I shall be enlightened. Where is that direction? Roman 1, Roman 2.
Yes, it is there, that is representation.
Correct.
And in the
See,
representation.
that is why I'm saying.
In the representation.
He can address. So which he has done, and they have considered and they have passed some order. That order may be correct, maybe not correct. That part, this court will not go into it, isn't it? That if you are not satisfied with the manner in which your representation have been disposed of, you can file appropriate.
My lord, in that case,
proceeding.
liberty may be given to.
That liberty you don't need anyway. I can make an observation, but what is this In every cases, you people seek for liberties to file something which you already have that right in law.
Because I am not there to.
Anyway, your this court appreciates your assistance as an amicus, Mr. Chakraborty, but
Lordship, may I make a submission?
Is the petitioner in person?
you are represented by an amicus. Yes, what do you want to say?
Lordship, what I feel that there was an undertaking by the respondents that the process for
Is going on.
payment of the
Is going
higher
on.
salary and the non-practicing allowance has already been initiated
Initiated.
to grant the benefits to the petitioner in person. That is an understanding,
Very well.
undertaking, Lordship.
Very well.
And that was violated.
You see, just next to that sentence, what is written, Mr. Chakraborty? Please show it to your. Please show it to the petitioner in person. Please show. Immediate next sentence
Representation.
in Roman 2.
17.
All right. Heard, Mr. This is item number
55.
55. Heard, Mr. You're for
I'm
S.
the-
Chakraborty.
Yes.
Why your name is in the
I do not
respondent?
know.
Mr. S. Chakraborty, learned amicus curiae for the petitioner. Also heard Mr. H. Haliha, learned counsel, appearing for respondent number 2.
1 and 2, both.
For the respondents. By filing this petition under section 12 of the Contempt of Courts Act 1971, read with article 215 of the Constitution of India, for alleged willful and deliberate violation of the order dated 8/3/2019 passed by this court in WPC 5471 of 2014. And IA Civil 3370 of 2018. The facts of the case is that the petitioner, by filing writ petition IWPC 5471 of 2014, was primarily seeking regularization of his service as professor of medicine in Assam Medical College, Dibrugarh, with retrospective effect from 1/4/1997.
97.
Huh?
1497.
1/4/1997.
97. Yes.
Yes, that's what I've said. Okay, what did I say? Yeah.
I thought it's 90. I heard 96.
This court, upon hearing the parties and considering the grievance raised therein, was pleased to close the said writ petition with the following observations. Page 17, 1, 2, 3. Mr. S. Chakraborty, learned amicus theory, submits that though area salaries pursuant to the filing of the contempt petition has been released by the respondent authorities. However, it falls short of the actual arrear due to the petitioner. He accordingly submits that the order of this court is not complied in full spirit, and as such the respondent have committed contempt of court. Stop. He further submits that before the writ proceeding in WPC 5471 of 2014, the Standing Council Health Department has given an undertaking that steps has already been initiated to grant the benefits to the petitioner in person, and therefore there is contempt of the aforesaid undertaking. Stop. Per contra, next para. Per contra, Mr. H. Halia, Learned Counsel have submit Learned Counsel for the contemners have submitted that in terms of the order dated 8/3/2019, this the Commissioner and Secretary to the Government of Assam Medical Education and Research Department has considered the representation of the petitioner and disposed the same. He further submits that the arrear salary as per available records amounting to rupees 83.11906 is also paid. He accordingly submits that the order of this court has been fully complied, and there is nothing.
Non-practicing allowance was also, we have paid an amount of 16 lakhs, that Lordship. It's
where is that?
The second paragraph, Lordship. Third.
Along with the non-practicing allowance amounting to rupees 16.23834 lakhs. He accordingly submits that there survives nothing for adjudication in the instant contempt petition. Stop. I have given my prudent consideration to the arguments made by both sides and have perused the materials available on record. Since this petition has been filed by the petitioner, drawing the attention of the court for the alleged non-compliance of the order dated 8/3/2019, passed in WPC 5471 of 2014, apt to refer to the said order at the outset. I have referred this earlier, no, on top, that Roman 1 and 2 of page 17. We will do the extraction here, okay? That part you just highlight, I will edit it later. Now you say, paragraph 5 of the said judgment is reproduced hereunder for ready reference. Page 17, huh? A to A. Okay. It appears that this court, while closing the said writ petition, directed the respondents to dispose of the representation filed by the petitioner preferably within an outer period of 3 months, and upon the said and upon passing of the speaking order, to communicate the same to the petitioner in person. Stop. It further appears that in view of the submission of the petitioner in person that he has not been receiving his arrear salary as well as non-practicing allowance, comma, in which regard the Learned Standing Counsel for the Health Department has submitted that steps as has already been initiated to grant the said benefits to the petitioner in person, comma, this court provided that the petitioner in person would be free to raise his grievance for the same in his representation if needed. Stop. A perusal of the order dated 7/9/2024.
Yes, the speaking order, Lordship.
7/9/2024 indicates that the respondents have paid the arrear salary as well as non-practicing allowance amounting to rupees 83.11906 lakhs and rupees 16.23834 lakhs respectively. It further appears that the representation of the petitioner has been also considered and disposed of by the said order. It further appears that the said order has also been communicated to the petitioner in person. The dispute as regards the amounts, as regards the area salary as well as non-practicing allowance, cannot be gone into by this court while exercising contempt jurisdiction. Be that as it may, once the petitioner files a contempt petition, thereafter it is between the contemner and the court, and the limited role of the petitioner is only to bring it to the notice of the court as regards the non-compliance. Stop. Upon receiving the notice and the upon the materials being placed before this court by the contemner, comma, if the court is satisfied that the order of this court has been complied, comma, nothing further would survive for adjudication. That being so, in the present contempt petition, the direction passed by this court in WPC 5471/2014 by order dated 8/3/2019 stands complied. So, accordingly, nothing survives for adjudication. Contempt petition stands closed. It is needless to this. I don't think it is required, Mr. Chakraborty. This court appreciates the assistance rendered by Mr. S. Chakraborty as amicus curiae. Fees will be there.
I don't know, my lord. One observation that the grievance may be, because it's a long time.
I will edit it.
Lordship, the grievance is only regarding arrear salary, non-practicing allowance. I don't think my learned friend.
Whatever grievance is there,
Lordship,
in the matter of computation.
Obliged, Lordship.
I will add a line that, however, such grievance where I have said cannot be gone into this court, I'll say it is open for the petitioner to redress it before the appropriate file. I'll add that in that paragraph.
Yes.
just write it and I'll add it. However, it is open for the petitioner to redress such grievances before the appropriate forum.
56.
Disposed of.
May I take? This is violation of the order dated, order dated 15/6/2022.
Yes.
Affidavit is sent for vetting. Affidavit is sent for vetting.
All right, you file it then. As prayed for by MS
N. Bora.
N. Bora, learned counsel for the respondent, which is not objected by the, which is not opposed by the other side, list this matter after 10 days on a date to be fixed by the registry to enable the respondent to file their return in the matter.
Right.
Non-compliance of the order dated 26/9, 26/9/2023, operative person page 43. 26/9/2023, 22, page 41.
Page
41. And operative person page 43.
Yes.
Accordingly, the respondent in
You have not filed anything till now.
Let's say we have received some instructions. Here said pensionary benefits such as provisional pension, leave encashment benefits, group insurance scheme benefits, and provisional death cum retirement gratuity benefits has already been sanctioned. So let's say
not released, my lord.
Do you get an update up because the order it says
2017-2 last order, my lord. 17-2, my lord.
No,
2024.
the order that you are saying has been not complied is the order dated 26/9/2022. Accordingly, respondents in PNRD are directed to process the family pension and complete the same and bring it to its logical end.
Within 6 weeks
So
from the
you are
date of
saying
receipt.
it has been processed, but it is not concluded. Till it is not concluded, you have not followed. Yes.
So let's say we have some queries.
Huh?
So, because it is
Ms. Bora, you are understanding what this court is saying. You have to bring the proceeding to a logical conclusion. Otherwise, this court will held you in contempt. Held your the authority, the hearing officer.
Lordship it's already sanctioned, but
Sanctioned but not released.
Lordship,
Logical end means what? What is logical end?
for that purpose, let's say we have some queries, so we'll take up to date instructions.
Right. As prayed for by MS
N. Bora.
N. Bora, learned counsel for the respondent, list this matter after 2 weeks on a date to be fixed by the registry to place the updated instruction in the matter. Updated status of the release of family pension to the petitioner.
All right.
Yes, Mr. Gogoi.
Lordship.
Instructions?
Yes, Sir, Lordship. I have received written instructions and we have submitted everything to the AG, Your Lordship.
Huh?
We have forwarded everything to the AG, Your Lordship.
You are taking Mr. Das by surprise. Mr. Das, are you aware of what is happening?
Yes, I am aware of, but they have not done anything.
What is the order?
Page 17.
Page
17.
17.
Yes. Last 2 lines, 2 sentences.
One second. Yes.
Last 2 sentences. For the reasons stated herein above,
yes,
this court is of the considered opinion that the impugn order dated so and so qua the petitioner, thus cancelling his order of regularization, is on the face of it arbitrary and illegal.
So to give consequential benefit pursuant to his regularization,
yes,
after adjusting the pecuniary benefit. Yes, what have you done?
Lordship, we have collected all the pension payment. We have forwarded to AG, Your Lordship. Now the AG has to release the payment, Your Lordship.
Was there any time frame given in this?
It was given 3 months.
3 months expired.
3 months expired, Lordship.
Why is it taking so much long time then? Because if
Because
it
in
is
the-
expired, then means you have committed contempt.
In the
This order is of 19/7/23,
Yes, sir,
3
Lordship.
months
In the-
expired long back.
In the meantime, department was sought for going for review, Your Lordship, but they didn't go for review.
So how much more time?
AG has to apprise the Lordship. We have
Who is appearing for the AG? Because this court is not considered about the individual performance of the officers. The court is only concerned about the compliance of this court's order.
That-
Apparent that it has not been complied till date.
the
If
PH
you-
the PH is forward the paying authority is the AG, Your Lordship.
Who is
PH
appearing for the AG?
That's AG party one is in AG party line.
Mr. Das, he is not a party.
Not a party.
AG was not party in earlier thing.
Finance,
But we can always come here.
are you there?
Yes.
We are the Lordship.
Respondent?
Yes, for respondent number 7, Lordship. We have given an approval pursuant to our approval only, Lordship. These steps have been
This has
initiated.
been initiated.
You see, now it is up to you to get this sanction and placed before this court.
That we have given our approval, Lordship. Now why the AG?
AG.
From what I understand, my learned friend has forwarded the documents. So if the AG, Lordship, we can communicate, but if the AG is not acting upon it, Lordship, then the problem is if he's made a party, then he'll be answerable, Lordship, because he's not under our, he's not
They have not given any affidavit. If they give affidavit, I can make AG a party. Whoever comes in between, my lord, they can be made party in contempt case.
If they can just bring it to notice, Lordship, because he's the one who is obstructing the court's order.
Yes, but you have to bring this to the notice of the petitioner.
Lordship, they are aware, Lordship, and this order, Lordship, we had already placed.
Which order?
Our approval order, Lordship, that was already placed. Now, if
Then Mr. Das, why don't you? Yes, in fact, Mr. Das, on the last occasion, this has been given. The communication, he's right. 27 August 24. Sri R.R. Gogoi places before this court a communication dated 22/7/24 issued by the Executive Engineer PHE Umrangshu Division for the Accountant General Assam in respect of pension payment of Das. See, Mr. Das, this court is trying to help you.
Yes.
If you want that, because as it appears, everything has been done from the respondents, right? Now, what is remaining is the consequential action of the AG.
Exactly.
Now, that AG office is not represented.
One thing is not clear here, because court directed a consequential benefit. That means his regulation order was cancelled.
You see, unless and until the order comes, we don't know what the order will contain.
We also do not know from
So,
their end.
why don't
What
you
is the-
have to cut the controversy short? Why don't you array this AG?
We'll
You array the AG.
Yes, Lordship,
This will
he'll be able to explain.
make it.
All right. It is submitted by Sri R.R. Gogoi Learned Counsel that the subject pension by the finance, the matter has been placed before the Office of the Accountant General within bracket A&E Assam for
releasing of the
release.
for releasing the conjugal
For
benefits.
releasing the subject pension. Stop. However, it appears that the Accountant General A&E Assam is not a party in the present contempt proceedings. Mr. B. Das, Learned Senior Counsel, assisted by so and so, seeks 2 weeks' time to take to obtain instructions and do the needful in the matter. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Only one aspect of the matter. You'll also kindly see page 17. Page 17 says regulation order which was cancelled, it was put to effect.
Consequential benefit.
2006.
Consequential benefit.
So salary difference, you will get the salary difference. What is the salary difference? They are not saying so.
No. In the meantime, let the respondents file their return in the matter. You all file and clarify whatever is there.
Very well.
You file an
Salary
affidavit.
area.
Whatever
Salary
you
area.
have to say, you file it, because you see, if in a given state this court comes to a conclusion that something from your end has not been done, then there will be difficulty.
Yes,
They have not done
So
this, my lord.
you file it.
Because his regulation was cancelled since 2005.
File. Yes, Miss Som.
My lord,
Affidavits not filed, Mr.
My
Datta.
lord, we have filed today, my lord.
You filed today.
My lord, we have already
You have received.
No, I have not received.
Well, we have served a copy, I think, to her clerk possibly.
I do not know. I have no
The
idea.
problem is you authorize your clerks to accept copies on your behalf, and there are many times when the clerks do not inform you in time.
Yes.
I
No,
think
if
this
she hasn't-
this practice should be stopped.
Yes, yes.
No, I have
there-
not instructed my
No,
client
but
to receive it,
otherwise,
and they
why
have
should
not
a
done
clerk accept then?
it. Yes. Lord.
Anyways, because unless it is accepted, it will not be the registry will also not accept
Yes, yes.
unless it's.
So why they have served to clerk? And that
Anyway,
is also-
Well, this is the practice
it
prevailing.
appears Mr. S. Datta, learned counsel for the petitioner, submits that an affidavit has been filed today. However, neither the same has been received by MS S. Som, learned counsel for the T. Som, learned counsel for the petitioner, nor the same is available on record. Let registry verify and place the same on record.
Lordship, may I pray, Lordship? She is at the verge of retirement and she is entitled.
List this matter next week
Tomorrow.
on a date to be fixed by the registry.
Lordship, date may be fixed, Lordship.
All right, next week. Yes.
May please, Lord.
Yes, Mr. Smith.
This interlocutory application was filed for correction of the name of the respondent number 4, my lord.
There's an IA.
My lord.
IA Tracity. For correction.
Of the name of the respondent number 4, my lord. It should have been Jyoti Basumatari, but.
All right. Anybody in the opposite side?
DA, my lord.
Heard Mr. M. Smith, learned counsel for the petitioner. Also heard MS M. Bhattacharya, learned counsel for respondent number. I think only one.
But for 1, my lord.
One, right, Ms. Bhattacharya?
Lordship.
Government of Assam.
Director of Sports, no, we will be appearing.
1 and 2.
1, 2, and 3, Lordship.
1, 2, and 3.
3, stop.
Oh, Sai, Lordship. No, 1 and 2, Lordship.
1 and 2. By
But
this
you have not provided
application,
us the copy.
the applicant is seeking correction of the name of the respondent number 4 which will be the correct name
My lord, Jyoti Basumatari, my lord.
as Jyoti Basumutari
My lord.
instead of Bharat Basumutari in WPC number 3445 of 2024. It appears that the name of respondent number 4 has been inadvertently typed as Bharat Basumutari in the cause title of WPC 3445 of 2020. In view of the above, this court, in the interest of justice, allows the instant interlocutory application by allowing that the name of the respondent number 4 in WPC 3445 of 2020 be corrected as Jyoti Basumatari. Let an amended cause title be submitted to the registry for doing the needful. Allowed.
I mean, I'll be allowed to take service on respondent number 4, my lord.
In the main petition, in view of the order passed in IA number 2881 of 2024, let notice be issued to respondent number 4 in the corrected so and so by registered post AD. Steps to be taken within a period of 3 days. List after 3 weeks on a date to be fixed by the registry.
Interim order is done.
Interim order, if any, shall continue till the next date of listing.
Lordship, in this case, the petitioner was working as a LDA in the Department of Director of Medical Education.
This is a hearing matter.
Your Lordship, as per the order dated 14/3/2024, the respondent number 2, they were directed to procure certain instructions.
The senior counsel is on Rexing Court 2.
We'll have it on another date.
Lordship, on several occasions also.
No, their instructions are awaiting. Health and family.
Yes.
Health and family. Necessary instructions as ordered by this court on 14/3/24. It appears that the instructions call for from the Standing Council Health and Family Welfare Department in terms of this court's order dated 14/3/2024 is not yet furnished before this court, is not yet placed before this court. Stop. Be it as it may, by way of a last chance, the respondent Health and Family Welfare Department is given 3 weeks time to place these said instructions by the next date of listing. List after 3 weeks
Date may fix your lordship.
on such and such day.
Obliged.
64.
Yes, what is this matter? Promotion of respondent 5 to additional chief engineer.
Yes, my
R5 is Mr. Deka.
Yes. Yes, my He's for respondent 5.
Yes.
Now, my lord, the challenge has been made to the promotion of the respondent number 5 and my lord, non-consideration of the case of the petitioners. Because one issue, my lord, whether the MSc degree in ecology and environment is a part of the MSc biological sciences or equivalent thereto for the purpose of promotion.
MSc degree.
My lord. Now, my lord,
Whether it is equivalent to
my lord, whether this is MSc degree in ecology and environment is a part of the MSc in biological sciences or not.
that is the issue.
That is the issue. Now, my lord, before proceeding further, my lord, I'd like to inform your lordship that there are two petitioners. Petitioner number 2 has already attained the years of superannuation. Sorry, my lord, petitioner number 1 has attained the superannuation on 31/8/2023. And the petitioner number 2 is retiring on, my lord, 31st of January 2025.
31st January 25.
Now, the order of promotion which is under challenge that your lordship finds at page 79.
So as far as P1 is concerned, it would be notional.
Yes.
The benefits.
Yes.
If at all
If
this
at all,
court
yes.
comes to a finding.
No, in fact, my lord, for that also, my lord, the selection committee has to be constituted again. It's not that, my lord, your lordship will be.
So does anything survive then for P1?
It does in the sense that, my lord, his case was not considered in the, my lord, earlier proceeding. In fact, my lord, the selection procedure itself is more faulty in the sense that the rules require that a selection committee has to be constituted. And here, my lord, board took a decision itself. It was high-handed, my lord. They were against the petitioners.
So your challenge is to the manner in which the selection committee has been constituted.
That is one part, because, my lord, that we came to know only after filing of the affidavit where they have, my lord, annexed the
But
findings.
then you must have taken up this point in your rejoinder.
Yes, ma'am. Now, the impugn order at page 79 only says, my lord.
79.
79. The first order is relevant. In the interest of public as well as board's service and as per the decision of the selection committee meeting held on 27/2022, Sri Manoj Saikia, who is the private respondent, senior environment scientist, is promoted. R5.
Yes.
Is promoted to the rank of additional chief environment scientist in the payment of rupees so and so per month plus other analysis with effect from the date of his joining. Now, before, my lord, I take your lordship to the minutes. My lord, there is a my lord, history of this case, my lord, which may be relevant. There is an earlier order of this honorable court where, my lord, this issue regarding this MSc degree was considered by this honorable court. Your lordship may kindly come to page 30, which is the earlier judgment.
Page?
Page 30.
Yes.
This was filed by the petitioner number 2 herein. And my lord,
Medul Dev Adhikari is P2.
He is the, my lord, petitioner.
P2.
And my lord, there is another writ petition decided together, which was filed by the respondent number 5.
This Manoj Saikya.
My lord. My lord, Justice Bhuyan.
Huh?
Justice Bhuyan, my lord. Manoj Saikya is the, my lord, respondent number 5. Yes.
No, that's what. Manoj Saikya is respondent number 5,
yes,
correct?
Yes.
Because you said 2 writ petition.
2 writ. Yes.
Yes, yes.
Now, your lordship may skip the, my lord, discussions and come to page 40, where the direction has been issued.
Yes, para 27.
Paragraph 27.
Yes.
Your lordship may also read paragraph 26, my lord.
Yes.
The question whether MSc in Ecology and Environment is a part of the MSc in Biological Sciences or equivalent thereto is a matter to be examined and decided by the experts. It is neither possible nor desirable for the writ court to embark upon such an exercise, which should be best left to be decided by the experts. Then 27. Therefore, in the light of the discussions made above and without expressing any opinion on the merit of the controversy, it is hereby directed that the member secretary of the board shall place the matter as to whether MSc in Ecology and Environment is a part of MSc in Biological Sciences or equivalent thereto for the purpose of promotion to the post of deputy analyst and analyst before the board for taking an appropriate decision in consultation with the experts. Let the said decision be taken by the board within a period of 3 months. Then thereafter, my lord, the board had taken a decision that your lordship finds at page 43.
Yes.
This is an order dated 6 July 2015, pursuant to the direction passed by the Honorable Guwahati High Court in WPC so and also in consideration of the opinion of the expert committee constituted by the board in its board meeting on direction of the Honorable High Court, which concludes that the MSc in Ecology and Environment is a part of MSc in Biological Science for the purpose of promotion to the post of deputy analyst and analyst re-designated as
So
senior.
it says it's a part.
My lord?
It says it is a part.
Yes.
It is a part.
Now, my lord, in spite of this decision of the board, my lord, now the board again has taken a decision that, my lord, our degrees cannot be considered. That
But this says it is a part.
Yes, ma'am.
Then where is the difficulty of not accepting the decision of the board?
The board itself, my lord, now says in the affidavit in opposition, your lordship will find they have given the minus.
Where is your prayer?
My prayer, your lordship will find
page 18.
Page 18, page 19, my lord. Issue written in the nature of certiorari, setting aside the impugned office order dated 22/7/2022 insofar as it relates to the promotion of the respondent number 5. Then, my lord,
So this order is 22/7/22. Where do we get this order? 22/7/22.
That page 79, my lord, that your lordship has just read.
Now page 79.
That is the promotion order of the private.
No, but here they do not say that they have not considered your case.
Yes, my lord.
That is not said anything.
That is not reflected here.
In the affidavit, they are saying that
in
you
the
are
affidavit,
not,
my lord, they have annexed the, my lord, the minus of the meeting of the board.
where they are not recognizing this degree as equivalent.
Yes.
But then that would be against the order of this court, because the order the order that you have shown at page 43 is pursuant to the direction of this court, whereby the board had
Already decided. That it is equivalent. It has to be accepted for the purpose of promotion.
Is this the only short point involved?
In fact, my lord, this is the main issue involved.
No, because if this is the only point, then we will ask the respondents to clarify as how they are not accepting this order at 6 July 2015.
Exactly, my lord.
Because if this order stands, they are bound by it. How and in which part of their affidavit they have said that you do not have this degree?
My lord, that is the, my lord, in their affidavit in opposition. By the file by the respondent.
Mr. Borra, you are following?
Yeah. The, my lord, minutes of the board meeting is at page 102.
102. Yes.
The relevant, my lord, agenda item is at page 103, agenda item number 104.6.
Yes.
The board discussed the agenda in detail, including Supreme Court order in Professor Yashpal, the state of Chhattisgarh case, UGC clarification regarding permission granted to Sikkim Manipal University to open distance education center through franchisee, etc. The board observed that the Indian Institute of Ecology and Environment, which issued the master's degree to the two of the board scientists, namely Usidas, the petitioner, and Sri M.D. Adhikari, another petitioner, was never.
These are the petitioner 1 and 2.
My lord. Was never in the book of UGC, and the said private institute was found out to be a study center of SMU. Besides, SMU operated the study center without any approval from the UGC. Now they are taking, my lord, other grounds. The board also noted that the eligibility criteria of admission into the MSc course also included even arts and commerce graduate, which is absolutely in contradiction to the nature of the work in PCBA. It was Pollution Control Board. It was resolved by the board that for the coveted post of ACES, the candidate must have a master's degree from a regular university, and one should have the experience of laboratory analyst from the eligibility criteria of candidates for the said distance education degree. It was understood that the said MSc course lacked the laboratory analysis module. The board took a strong resolution that the board needed a scientist to head the laboratory with a regular master's degree from the UGC recognized university. After deliberation on the issue, and also considering the comment of the Standing Council that the order of the Supreme Court in the year 2012 should be honored and mistake already done should not be repeated, the board took the resolution that the candidature of Umesh Das and Mridul Devadekari, who obtained degree from distance course, could not be considered for next promotion. Hence, the Manoj Saikia, SCS, who is having master's degree in chemistry from Guwahati University, to be considered for next promotion. Now, my lord, this is a, my lord, resolution of the board, my lord. This is not a selection committee. Now, the rules require that, my lord, the selection has to be done by a selection committee. Thereafter, my lord, it will go to the, my lord, appropriate authority. Now, board itself takes a resolution that his case should not be considered and Resolution number 5 should be appointed. And the ground taken is that, my lord, the degree has been obtained by distance education.
No, but before that, what is this? They are saying that the board observed that the Indian Institute of Ecology and Environment, which issued the master's degree to the said two petitioners, was never in the book of UGC?
That is not correct, my lord. We have given in the affidavit of reply. That is not correct. That is not correct, my lord. In the writ petition itself,
if
my
you are
lord,
disputing to your very degree,
my lord,
how will this court go into all this?
No, my lord, my submission with your lordship is that the validity of the, my lord, the degree, they do not say, my lord, the degree is not valid.
They are saying it is not available in the books of the university.
My lord, that, my lord, I'll satisfy your lordship on that point. But here, my lord, the degree is not questioned. It is the manner in which the degree has been obtained. That is what has been discussed in the board meeting, which they cannot, my lord. And so far as, my lord, the distance education is concerned, it is not that, my lord, we had taken the distance education course and, my lord, here, my lord, in Assam. We had taken the distance education course, but, my lord, the examination center was there at that point of time and the UGC approved that. I'll satisfy your lordship on that. So this is a question, my lord, after the, my lord, this honorable court directs them to decide on our MSc degree, they decide that, my lord, it can be considered for promotion. Now they are taking a different stand on the, my lord, degree based on a, my lord, Supreme Court decision which was there, my lord, when the earlier decision was taken by this honorable court, asking them to decide whether my master's degree is to be considered or not. Now, if your lordship kindly comes to my writ petition, in the writ petition itself, my lord, if your lordship kindly comes to page 77, that is the communication from the, my lord, UGC to the Environment and Forest Department, Government of Pollution Control Board, my lord. There, the situations have been clarified.
70
is 77.
Yes.
This is regarding validity of MSc degree acquired from Sikkim Manipal University, Sikkim. Your lordship may come to my lord, clause 2. Sikkim Manipal University, Sikkim in the state of, is a state private university. It was accorded post-fact to recognition from 1995 to 2006-2007 by the erstwhile DEC, Distance Education Council, IGNO, to offer programs as approved by statutory bodies of the university through distance mode. It was further accorded provisional recognition to offer distance education program for the year 2007-8 and 2008-9. The program-wise recognition was granted for a period of 3 years from the academic year 2009-10 to 2011-12. No further recognition was granted to the SMU. Now, I'm pausing here for a while. The petitioner number 2 obtained this degree in 2003. This covers it, my lord. And petitioner number 2 in 2009. So both the periods is covered. So after this, my lord, they cannot question the validity of the degree which has been, my lord, granted by the SMU. And that too, my lord, here they do not say that the degree is not valid because they cannot say. But, my lord, the manner in which we have obtained that degree, that has now been questioned. After, my lord, there was
These
already...
minutes are under challenge.
My lord?
The minute.
No, my lord, we have not challenged that because this came in the affidavit in opposition. We have challenged the promotion on the basis of this. The promotion was given to the respondent number 5. And, my lord, this resolution.
Not understood properly the reason for not promoting you as it appears at page 103. 103, that minutes.
Yes, my lord.
What are the reasons that they have said? Let us understand that.
Yes, my lord. The reason says
number one, that degree is not available in the UGC.
Yes.
This is one.
Yes.
And then that is one ground they are saying.
Yes.
Second.
And it is in distance mode.
And it is in
distance mode, no laboratory.
Distance course.
Yes. Distance mode. These are the 2 grounds they have taken.
But how this code and exercise of 226 go into the merit of this decision? This court is only concerned with the decision making.
No, my lord, the decision making process, my lord. My lord, may I take your lordship to one document, my lord, at page 43.
Page 40?
43, my lord. Yeah, that your lordship has just read, my lord. They have already decided that this is, my lord, this MSc degree obtained by the petitioners, they are, my lord, eligible to be considered for promotion. And this has not been, my lord, overturned by them.
No, but in that minutes, they have not said that your case is rejected because you don't have this degree.
No, my lord, they don't say that.
They don't say that.
They say that, my lord.
Initially, I was of the impression that for that you have not been given. That is why I thought the issue, the controversy is very short. But now it appears the non-consideration of your case is not for non-possessing of this degree, but it is because they say, one, that it is not available in the books of UGC. Second, they say it is distant mode.
Yes. Now, my lord, the same board earlier, my lord, they have decided that this will be considered. This is can be considered. It has to be considered for the purpose of promotion. And that
earlier,
my lord, page 43.
CES. No, page 43 is the order which was in pursuance of the earlier direction of this court, as whether the MSc in ecology and environment is a part of MSc in biological science or not.
Yes, my lord.
That they have said, yes, it is part. Am I correct?
Yes, my lord, this is passed and it says, my lord, this is, my lord, because the direction of this honorable court was whether, my lord, this that will be taken into consideration for the purpose of promotion.
So they said yes.
So, my lord, they say yes.
Yes.
Now they are saying, my lord, we cannot consider it.
No, where
because
have
of
they
two
said
other
they cannot consider this
that, my lord, in the minutes of the board, not the
about
selection
this
committee.
degree? Which
That-
which
that I
part
have
in that
just, my lord,
minute?
pointed out.
No, that is exactly which I am not being fine. Which part where they have said that you do not have MSc in biological science
No, my lord, they say after deliberation, last paragraph at page 103.
after deliberation?
After deliberation on the issue, and also considering the comments of the Standing Council of the and that the order of the Supreme Court should be honored and mistake already done should not be repeated, the board took the resolution that the candidature of so and so who obtained degree from distance course of campus cannot be.
What
could
is
not be
distant course?
Distance course.
What does that mean?
Because, my lord, we had obtained the degree through distance mode, my lord.
Here, but in at page 43, this says distant course is acceptable. Is that correct, Mr.
No, never.
All right.
So this is the, my lord, the primary issue. And if your lordship, the rules are also clear on this, my lord. And, my lord, without a selection committee, it has been decided that we cannot be considered and the private restaurants should be promoted.
Mr. Bora, what is your stand as per page 43 and 103?
So, without confusing the court with those degree qualifications, environment, and that previously they have approached the court as regard whether they have degrees in environmental science and ecology should be deemed to be at par with MSc. So that point of time, when the court was deliberating upon the subject, whether these has to be added or not, then the court has directed the member secretary of the board to just constitute an expert committee so that who can sit across and find out whether these degrees also equates with the MSc degree. Finally, that subject has been set to rest. And subsequent to the decision arrived at by the expert committee, they have been promoted. But later on, it has transpired. So I have my affidavit is very clear as regards.
They have promoted means?
The petitioner along with two others.
They have been promoted?
Yes.
Subsequently.
Earlier promotion.
Earlier promotion, not this one. So now what has happened? After all the subtle principle, like when the expert has come to the conclusion that the MSc is a notified degree, ecological science. After that, what has happened? While deliberating, two things has come to light. While those matters were before the court, Honorable Single Court, the court didn't go deep into the merit of the case based on the deliberation that was happening in Supreme Court in Yaspal's case. The Professor Yaspal's case has pronounced it very clear, even though those points haven't been brought to the records of the case when it was deliberated before the Honorable High Court. Yaspal has made it very clear that no off-campus degrees or study centers open outside the territorial jurisdiction should be allowed to operate. So they have been negated totally. And in terms of that,
you have not challenged the order of this court.
Yes, look.
You have not challenged the earlier order of this court.
No, that's what I have clarified in my affidavit because that point was never placed before the court.
But you have also not subsequently challenged or reviewed or sought for review that the case of Yaspal.
Yaspal, we are not disputing Yaspal because Yaspal is something that is going against their interest. But after the Yaspal, the Director of Higher Education have also passed an official circular whereby they have stated that no degrees, so for that matter, I would like your lordship to take to that.
I think this matter will take some time. Perhaps it will not be possible for this court to dispose it of within the next few minutes at this fag end. So we can have it on a hearing day. We'll have to. When do you want it? Tell me. When can we have it? Any hearing?
So maybe after the post application, because ultimately this
Mr. Chaudhary?
One client is retired, one is retired.
Yes, that's why I'm asking. When can we have it on a hearing day? Because it is going to take some time. Mr. Decca is also there,
He'll have to
waiting
arrange.
to open his brief.
Even
When
though
can
the
we have
subject
it?
is very simple, but it is getting complicated.
It
because
is
of the
getting
issues.
complicated,
Yes.
and at the fag end,
Yeah.
after taking up
The whole,
almost
that's
60 to
what-
70 matters.
The fresh mind doesn't.
Yes. Perhaps on a Tuesday or a Thursday in the next week.
No, not it. Let it be after the vacation.
No. There, one has already retired. One is about to retire on 31 January 25.
Because next
Let's try and make an attempt.
No difficulty. On 26th, I will not be here. So on
24th?
24th it is taken up. I have not.
All right.
24th is Tuesday.
24th is okay because Mr. Decca won't be available there.
On Thursday.
See, 24th will be easy for this court because this court has heard
Yes.
the petitioner to some length, so it will be fresh.
I've got a long matter fixed on 24th, but even then, let me take a
You
chance.
have otherwise almost finished your part. Now I think
I
the
have to give
reply
the
part. Reply part. So let me hear Mr. Borwa and Mr. Decca, and then you give your reply.
Also, on 24th, I have some fixed matters. If
Okay,
at all
shall I
it
fix
doesn't
this
clashes.
at 2 o'clock?
If at all it doesn't
I can
clashes.
fix this matter at 2 o'clock. All right, at 2.
Yes.
Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. M. Sharma, Learned Counsel for the petitioners. Also heard Mr. S. Borwa, Learned Counsel, you're appearing as government advocate.
No, for the standing council position.
Learned Standing Council, Pollution Board. Mr. N. Decca, Learned Counsel for respondent number 5. MS Chamwa on behalf. Your name?
UGC.
K. Barbujari. K. Barbujari on behalf of H. Omwa, Learned Counsel appearing for UGC. Respondent number 6. 4. Arguments of Mr. M.K. Chaudhary is completed. List on Tuesday, date to Didia, on such and such date at 2 for hearing the respondents. Part heard.